Hi, everybody. Welcome to our webinar on capital increases. Its title is Successful Financing Rounds, Avoiding Legal Stumbling Blocks. Companies regularly need capital to finance their growth. And you regularly hear, especially in the startup space, that you need a product, you need a business case, and you need a good pitch deck to find investors for a funding round. That's absolutely true, but it's not the whole truth. Equally important are the legal requirements. Legally, a funding round is a capital increase, and capital increases are meticulously regulated. Therefore, a careful planning of the capital increase is a key aspect of the whole process. If mistakes are made or individual steps are forgotten and skipped, then you have to go one round back, make up what you forgot in the last round or correct the errors you made, and this entails a lot of administrative work. This is annoying, and even worse is when the capital is already paid into the capital deposit account, but you cannot access it because it is still blocked because the capital increase is not finalized and the new articles of association are not registered or filed with the commercial registers yet due to errors. We have Dr. Nando Stauffer von May with us today, who will guide us through the shoals of a legal or of the legal shoals of a capital increase. And even with prior knowledge and awareness of the requirements, you can still make many errors because the whole process is very prone to error and time-consuming. Luckily, we are in a time with technical developments where technical means can support us a lot and reduce the risk of errors and also be more efficient and help us save time. And in the second part of this webinar, I will elaborate a little bit on the technical possibilities to speed up the process and also improve the quality of that process. And at the very end of our webinar, you will have the possibility to raise any questions to Nando or to myself. So everything you always wanted to ask a lawyer. So Nando, welcome in our webinar, or thanks a lot for having us. We are today in your law firm and in your cabinet. So please tell us a little bit about yourself and introduce yourself to our audience today.
Yes, hello also from my side. I'm a notary public admitted in the canton of Bern, but I do serve clients in the whole Switzerland. I'm also admitted to the bar, as you mentioned. I'm a lawyer, and you very often assist either Swiss startups or often foreign investors who invest into Swiss startups. And as a notary public, I do all the notarization that is required for a capital increase, and I'll guide the clients through the required steps that I will present right now then.
Okay, thank you very much. And we're excited to learn from you just in a couple of minutes what those legal requirements are and where those stumbling blocks are that are mentioned in the title. Just briefly, to my person as well, my name is Dominic Witz. I'm one of the co-founders of Consento. Consento is a digital platform that digitizes all the legal requirements of the founders and board members of stock corporations. The meetings that are necessary and the decisions that are necessary for capital increase are one solution, and we have also other solutions, in particular for capital increase, that we will talk about a little bit later. The last 7 or so years, I have been particularly active in the area of digitizing legal requirements. I've done this before also for capital market participants with capital market and financial market regulatory requirements. That was more in the banking area. And currently I'm doing this for my own startup, Consento. And as I said before, We will dive a little bit deeper into this topic later on in the second part of this presentation and webinar. But let's start with the actual topic, namely the legal framework of a capital increase. As I said, it's heavily regulated, and it's very decisive that you pay attention to all those small little details. Although most of the people who perform a capital increase for the first time think it's an easy process, and actually the hardest is to find the investors. But that's not the only challenge. Please, Nando, the stage is yours. Present us, please, all those tricky legal requirements.
Yes, thank you, Dominic. Well, first of all, at the very beginning, you have to decide which kind of capital increase you're aiming for. There are three different ways to increase the capital. We have an ordinary capital increase, we have a capital band, and we have a contingent capital. If your company is a LLC, so a GmbH or a SRL, then you only have one option. This is the ordinary capital increase. Whereas when you have a limited company, so an AG or an SA, then you have all the three options available. If you opt for the ordinary capital increase, which is basically the fastest way, so that's why we have here the rocket, then you have to be able also to complete it within 6 months' time. If you opt for the capital band, then you have a period of 5 years that allows you to increase, and depending on the wording of the capital band, also to decrease the capital. And as a third option, you have the contingent capital, which is often used for convertible loans or for employees who are granted option rights for shares.
May I just briefly jump in here? You just mentioned the limited liability company, or the SRL. We see this a lot also in the participants who registered for this webinar. We see once in a while representatives of an SRL. How hard is it to perform a capital increase with an SRL, or do you recommend doing this over transforming the legal form into a stock corporation?
Well, if there are a limited number of shareholders or of investors, then I think the GmbH is still a valid option. But very often I see often in the first financing round, then the GmbH will be converted into an AG. And in order to do that, you have to increase the capital, because very often you start with a 20,000 company capital for the GmbH, which is too little for an AG. So you first have to increase the capital to 100,000. Only thereafter you can make a transformation into an AG.
Classical chicken egg problem.
Exactly. But usually you then go for an ordinary capital increase.
Good. We skipped one slide, I think. That's the one we are on, right?
Yes. Yes. Once you decided which way to go, you have to call a shareholders meeting, because it's up to the shareholders to decide whether they agree to the capital increase or not. When you go for a ordinary capital increase, the shareholder meeting will decide on most of the points already now. When you go for the capital band or the contingent capital, then you basically delegate a lot of decisions to the board. All three versions have in common that you need to go to a notary. So that's where I come into play. And the shareholders meeting that decides on the capital increase has to be notarized. And when you decide a capital band or a contingent capital, then you have to amend the articles and include such capital band, contingent capital into the articles. And the articles then have to be adopted by the shareholders meeting and be legalized by a notary. Let's skip to the next one. So, and the shareholders meeting, it has to decide on the subscription rights of the shareholders. In an ordinary capital increase, it's really up to the shareholders meeting to decide on this issue. When they opt for a capital band, or a contingent capital, then you can delegate such decision to the board. Usually in case of a contingent capital, when you have a convertible loan or you have options from employees, then you exclude subscription rights of the existing shareholders. Now, after the shareholders meeting, when you opt for the capital band or the contingent capital, you have to file an application with the commercial registry so that it becomes public that you have a capital band and that you have a contingent capital. Whereas when you go for the ordinary capital increase, you go faster. You don't register right now. You continue with the process of the capital increase. So in order to continue, it's again up to the board. In an ordinary capital increase, most of the points have already been decided by the shareholders meeting. So the board only needs to decide what exactly has been decided yet. So for instance, the allocation of subscription rights of shareholders who did not use their subscription rights. So you have to allocate it to other and to possible investors. And with a capital band, when you then move forward, you really need a decision of the board to increase the capital. And with the contingent capital, you need usually you need a decision of the employees or of the one who grants a loan that he wants to use his conversion right or use his option for shares.
Before we go into the next topic, the subscription form, which is a very important one though, I would like to raise one more question. And on the previous slides, we saw three different types of capital: the ordinary capital increase, the capital band, and also the contingent capital. In the past, until the last revision of the Stock Corporate Act, we also had the authorized capital increase. And if I remember correctly, companies could decide on authorized capital until the 31st of December of last year, and those decisions are still valid for 2 years after decision, so which means for the next 14 months to come or so. So there are still a few authorized capitals around at the market that will be made use of. Can you please just briefly elaborate what the differences are on between the authorized capital and what needs to be done now, and then as a next step, the differences maybe from the ordinary capital?
Yeah, they're still authorized capital, although I see often that companies who have authorized capital, they also when they do a revision of the articles, they decide already to convert the authorized capital into a capital band. So very often it's replaced. And basically, if you follow now the next slides on the capital band, it's basically the same for the authorized capital. The main difference is that with the capital band, you can also decrease the capital, whereas with the authorized capital, you could only increase the capital.
Okay, thank you very much. So if you still have an authorized capital in your articles, you just follow the recipe of the ordinary, of the capital band. Yes, yeah. Exactly. Thank you.
Yeah, the subscription form, you mentioned it. It's really always a hassle because it needs to be subscribed by all the investors, so all the ones who join or take part of the capital increase. And they have to sign such subscription form. When you have a set off, so for instance with a convertible loan, then of course you also have to sign a declaration to offset the loan against the shares. And when you have a contingent capital, you also need a decision of the employees to use their option rights. Now it's the question, how do you sign the subscription form? Do you sign it on paper or can you do it somehow electronically? And the law here is pretty clear. Either you sign it on paper, wet ink, and you send the original hard copy to the notary. or to the company, right? And then it has to be presented to the notary, the original hard copy. Or you sign it digitally, but then you have to use a digitally signed digital signature that is admitted in Switzerland. And most common used means of digital signature, like DocuSign, is not admitted, at least not yet, in Switzerland. So if you want to check whether your digital signature is good, then you can use the validator, which I included here, the link, and see whether that fits. So if you have this qualified Swiss signature, which usually requires to go to a Swisscom shop to be identified, then you can also digitally sign and submit the subscription form.
Very clear legal requirements. You have two options, only two, and you have to pick either one. What I hear a lot in practice is that people write pages of instructions to the attention of investors on how they should sign. And then some mixed form that is not legally compliant comes back. For example, a PDF scan of an original handwritten signature, so wet ink, but then the form is being scanned and sent by email. Others scan it and sign it electronically, but just with a scribble, but not with the qualified electronic signature. What are your experiences? How can you manage those risks and avoid that 20, 30 shareholders each sign differently and in a manner that is not legally compliant?
Yeah, it's a challenge. You see already how I wrote it here on the slides. I really pointed out it has to be sent by post, UPS, DHL, FedEx. So it should make you clear that you have to send it the hard copy, the original one. But very often it happens that I receive a PDF scan and then I have to write back, please send me the original. And sometimes they send me then a printout of PDF scan, and because they already destroyed the real original, and then they have to send it again.
Exactly. So there are no limitations to fantasy, but fantasy is not the legally proper way to do it, right?
No, it doesn't bring you forward. Well, once you subscribe to the shares as investor, then you have to contribute. You have to contribute either cash, which is most of the cases the preferred mean, and such cash has to be paid in a special bank account, which will be blocked by the bank until the capital increase has been registered. You mentioned it before. So you can't pay it directly to the ordinary company's bank account. So that's very important. If the money is transferred from the company's bank account then to the blocked bank account, banks may cause problems and may refuse this. So it has really come usually directly from the investor to the blocked bank account. One can also agree on the contribution in kind. So what we see from time to time is this, an investor brings in like IP rights or any other means that is helpful for the company. If you do this, then you need an audit report which confirms the value of such assets. And then in case of a convertible loan or a short agreement for future equity, then it will be an offset. You will offset your loan against the payment of the shares. And for this, again, you need an audit report. And there's another option. You can use equity, and you can use basically its profits carried forward, and you can transform those profits carried forward into share capital. For this, again, you need a balance sheet that has been audited by an auditor. You need a capital increase report, and you also need an audit report on the capital increase report. So it's quite complicated. It needs a lot of involvement of the auditor, but it could be interesting in particular when you transform a GmbH into an AG. And if the GmbH, they have 80,000 profits carried forward, they can transform those 80,000 into share capital, and the founders will then receive all the shares, and then they can take it from there, the investment round. So. Well, I mentioned before the capital increase report. You need such report if there's a contribution in kind, if there's any set-off involved, so convertible loans, if there's transformation of equity capital, so the profits carried forward will transform it, and subscription rights have been cancelled. In those cases, you need a capital increase report.
I just see that we have a question, I think. Somebody has raised the hand, but I do not see a specific question. So if there is one, please feel free to type your question into the chat of this call. You see bottom row. A question, we cannot answer it just when you raise your hand, but please type your question into the chat and we will answer it as soon as possible. Thank you.
Yes, and if you have a capital increase report, then I mean, the capital increase report, sorry, it's always mandatory, but what I wanted to say is in those cases I mentioned before, and I have listed them here on this slide, then you also need an audit report. And this usually causes some delay because an auditor has to verify all the documents. Usually they have to ask questions, goes back and forth. The audit report will be required in again, an original hard copy, wet ink, or certified, digitally signed. So again, you lose time here, so it's the preferred option is always cash contribution.
Okay. Maybe just one point with regards to the exclusion of subscription rights. You mentioned this at the very beginning. It's something either the AGM can decide that there is an exclusion, or they can delegate this to the board of directors. So I think it sounds at the first glance like a formal, detailed distinction, but it has a big impact on whether somebody has to get an audit report or not, right?
Yes, absolutely. Yes.
We have a question. We would like to explore possibilities of allocation funds on consent. How is the funding stage? I'm not sure if I understand the question correctly, because allocating funds, how is the funding stage? So yeah, what I can describe regarding the workflow on how you perform the capital increase in the funding and how consent can support you with technical means is something that I would like to highlight in the second part. So I want to give Nando the opportunity to finalize on the legal requirements, and then we come to the technical possibilities and we will elaborate on that. So next slide, and we hide the questions. And I come back to your question just in a couple of minutes.
Perfect. So once the shares have been subscribed, the payments or the contributions have been made, capital increase report has been established, and if needs be, an audit report has been obtained, then there will be another board meeting. The board will formally take notes of all the documentations which is spoke before, and the board will then also amend the articles. It will update the capital in the articles, and this decision this needs to be authenticated by a notary again. So you always need 2 public deeds for any capital increase. Then the board has to sign this Lex Friedrich declaration. In some cantons, it's called Lex Kohler declaration. Both Mr. Friedrich and Mr. Kohler used to be federal counsels, and they worked on this law that restricts foreigners to to buy property in Switzerland. And there are some cantons, in particular Geneva and also Canton of Vaud, they're a bit more strict, so they require further certificates so that the company is not used, that's the aim of the whole thing, that the company is not used by foreigners to buy property in Switzerland. That's basically the idea of it, and you have to sign such declaration, and you have to be aware that in some cantons there might be further requirements which the notary should be aware of. So once you signed all those documents, you have to lodge them with the commercial registry, and in order to do this, you need an application form, and you submit this application form, which needs to be signed by 1 or 2 board members, depending on the signatory rights they have, and you have to lodge it together with the deed on the shareholders resolution, with the capital increase report, and then the deed on the board resolution, the amended articles, this Lex Friedrich declaration, and if you have a contribution in kind, then you need this agreement and also the audit report. Shall I continue? You have the question afterwards?
Yes, I think
okay.
so. We do the Q&A at the end.
Okay. And then you just mentioned it before, the money is blocked until the capital increase has been entered in the commercial registry. So once it has been entered, you can use the money, and you can also issue the shares. It's a bit same with the shares. Shares issued prior to registration, they are null and void. So that's why you have to wait for registration. Sometimes it's a bit difficult to explain to investors. They first have to pay the money, and then they have to wait until they receive the shares. But that's the way it is. And if you raise more than 1 million, then you have to pay a stamp duty. Should not forget that. You have to do it on your own. So you won't. Sometimes you receive a reminder, but then only months later when the tax authorities learn about the capital increase. But otherwise, you should do it on your own. So proactively submit a tax return on this. Otherwise, you risk to pay interest. Well, that's from the legal side. So I hand over back to you, Dominic.
So thank you very much. We heard the legal requirements. So even if you are aware of them, you still face some practical challenges. And these are the ones that I would like to address in the next couple of minutes and on the next couple of slides as well.
So the practical challenges we face is we have a lot of legal complexity, we just heard it. So, even if you have a lawyer or a competent notary who supports the full process, there's still a lot of stuff which needs to be done personally by the board members, for example, also by the shareholders. This is some tasks they cannot delegate, like filling in forms, signing forms, handing in forms the correct way. Then the whole process is very labor intensive. So you have your figures and your numbers on how many shares you want to create, at what price you want to issue that. And that information needs to be copied from one document to the other. And sometimes you have within the same document several copies. This is a manual copy-paste task, and everything that's manual is also prone to errors. So this is the last point on this slide. I jumped there a little bit. There are many copy-paste errors. It's very restricted to correct figures even after the comma. If something is not correct, you have to do it over. You have to fill in that form again, sign it again, or the worst case, sending again to the investor. We've heard this, that shareholders are a little bit impatient, so they paid in the money, they want to receive the shares, and if you have to do an additional tour to get documents corrected, this is of course annoying for everybody involved. Now, the third step that I just skipped before is the clarity of the workflow, respectively the lack of clarity in the workflow. So it's a complex workflow with many different tasks. You have take decisions in different type of meetings with different participants. You have to fill in all kind of different forms by different stakeholders. And for the board of the company in particular, it's always hard to keep the oversight of where you stand in the workflow. Obviously, the notary has it. He knows what needs to be done and what documents need to be handed in. But then it's also a question of communication and of the exchange between the different parties to know exactly where you stand in the workflow. So lack of clarity being another challenge. But we have more. One is the zero tolerance. I mentioned this before, right? If you have the smallest errors in one of those documents, you risk that you have to go back, because the notary public does his controls in order to assure the quality of the whole documentation, which is then also for the sake of transparency, of clarity within the commercial register. And after the notary, also the, what was he called? Manager of the commercial register will do the same controls again. So if there is any error, you risk that you receive the whole package of documents back and need to do it over. The whole process is very, very time consuming. Not only in terms of minutes and hours that you spend working on that project, but also the project time in itself. So I would say a well-organized capital increase where all the documents are made from the beginning lasts about 1 month or so. And if you're unlucky, you have 3 or more months until everything is done. And actually, the finish line that you want to cross is having everything filed in the commercial register. Only if the capital increase is reflected in the commercial register, you receive the money that is blocked on the capital deposit account, and only then the shareholders receive their shares. And so that time lapse between the beginning and the end of that flow be easily 3 months if you have any errors in the meantime. Then there are many meetings to be held. There's a sequence of meetings, so this also needs a lot of organization. You need to be aware where in the process you are and which type of meeting is the next one that's required. And then last but not least, you don't do capital increases just for the sake of a capital increase, but because you want to fund and grow a business. But the more time you need to spend on the capital increase and on the documentation, the less time you have for your day-to-day business. So that's another challenge. But as I said at the beginning, actually we live in glorious times. We have a lot of support by technical means. And there are many opportunities on how technology can support you in the process of a capital increase. And I just want to highlight a few of those milestones that can be achieved in the whole process. One is meeting automation. As I mentioned before, there are a series of meetings to be held. These are, in particular, the shareholder meetings that take the decision on the capital itself. Then we have board meetings, the board that decides on increasing the capital. And then finally, the meeting where the decision, the observation is done that the capital is increased and that the full set of documentation is complete. Here, modern technology and dedicated software can support you with pre-filled templates where all the agenda items and the motions are pre-worded the way you need them to pass the next step actually in front of the notary public and get that notarization. So that's one thing. With the whole automation that invites automatically all the necessary stakeholders and decision takers for each type of meeting. Then we have time saving and immediacy, which means that technology can also shorten the delays between the different steps. So, for example, if people do not have to travel to a meeting, but can do a meeting between two other meetings in their workday, for example, because they can do it online, you can save a lot of time. Also, obviously, stakeholders like the notary can be invited to an online platform. They can do their work online and even attend meeting online. The same with the auditor. If an auditor is necessary, he does not need to be the full set of documentation sent physically to his office, but he can join the data room online and have a look at all the documentation he needs to audit in an online tool. Then another aspect is decentralized collection of data. So the whole process is also very data intensive. You need to collect data on the company, on the capital increase, so how many shares you want to issue, at what price, what the nominal is, but then also data from the shareholder. And now it's a difference whether you have to be on the phone and talk to all the shareholders and write down the data yourself or copy paste it out of emails, or whether you have an application that allows for decentralized collection of data from the different stakeholder and sources that are involved and that contribute to that overall set of data and documentation. And then last but not least, a very important aspect where technology can also support you is in the process of the document creation. So you can also automate the documentation, the creation of the documentation. So one thing is that per use case, the whole set of documentation necessary is being created automatically in the first place. In the second place, is filled in automatically with the data that we collected in a decentralized manner the step before, and then being sent out to the different stakeholders automatically as well. So these are means that help you save a lot of time and also save a lot of money, and that reduce the risk of errors. They cannot exclude them 100% yet, but they can significantly reduce the risks of errors. So a couple of minutes ago, I read a question aloud that was raised by the audience, by chat, and it concerned the collection, I think, of capital. So I hope I answered at least partly that question with that slide here on how Consento can support. So I don't give you any fictitious example on, how potentially technology can support you, but the way Consento does effectively support you in your capital increase. We do not collect the money. That's the task of the bank. So the money is still paid into a bank account, but with everything around that, all the formalities that need to be done, the organizational aspects, the structure of the workflow, we can support you with our digital platform. I hope this answered one of the questions that were raised so far. We now come also to the Q&A session, and I see in the meantime some more questions were raised. One of them was, what is the fastest realistic timing to raise capital in terms of legal procedure? Is it better to use a CLA if quick cash is needed? Are the legal procedures much faster in other countries like in the USA or UK? Nando.
Well, I can't say much to the UK and to the USA. That's always where I refer to colleagues from those countries. But what I can say is it very much depends on the preparation on the side of the company and the investors. I mean, once I get all the information from the company, then I can draw up, and also Consento can draw up most of the documents needed within maybe 2 days, right? Then they have to be signed, payments have to be made. You can hold the shareholders meeting and the board meeting with an ordinary capital increase. You can hold them both on the same day, so that's feasible. You have to wait for the bank then to issue the payment confirmation. In the meantime, we collect the subscription forms, the capital increase report, and then we can hold the meetings even online. So it's theoretically it's possible to do it within 10 days, I would say. Then registration, depends very much on the canton. You have like canton of Zurich, you can pay something additional, and then they are really fast. Or you have other cantons which are usually faster than others. So that depends very much where the company is located. But I think it's realistic to have it done in 3 weeks maybe. When you are well prepared, then you have moment from the mandate you give to the notary until registration with the commercial registry. Realistic is maybe 3 weeks. But of course, very often it takes longer.
Okay, thank you. Then we have the second part of the same question, the CLA aspect. CLAs, that's definitely something you can speed up the process with. So correct me if I'm wrong, but in case of a CLA, you don't need to pay the money to a capital deposit account. So it's not blocked. You can pay it to or have it paid by the investors to the commercial banking account. So you can make use of it directly. But there is a restriction as well. You need to have the legal basis in your article of association to get a CLA or to get the contingent capital.
Exactly. When you want to transfer it later into share capital, then yeah.
Otherwise, you have a problem because you have received a loan, but you don't have a legal basis for the loan, no matter whether we have the CLA agreement in place. So the CLA agreement itself does not have a legal basis.
Exactly. I mean, I see very often that it's done without basis in the articles. Well, it can be done. It's then basically a loan, and you hope that you will receive shares later on. So you hope that the shareholders will decide on it. Sometimes you make some guarantees from the shareholders that they promise that they will decide a capital increase later on, but it carries some risks. Right. And then the next question is more related than to the physical presence of the notary, right?
In AGMs.
Of the AGM, yeah. It depends again on the articles, but in general, since the new law came into force on 1st of January, I authenticate without being present, right? So that's possible. If the articles allow for, you can even hold an AGM without venue so that everyone participates online, but this requires a provision in the articles.
And this is also a form how we cooperate.
Sure, yeah.
Your law firm and Consento. So our customers have their AGMs on Consento, and then the notary public will join the meeting, no matter whether it's the AGM or the board meeting, virtually online through Consento and means of video conference. Then we have another question. How faster can the financing software realize in comparison with the traditional approach? It's a hard question to really quantify this. I would say substantially. Again, it depends a lot how well you are prepared. The benefits of the software is that it gives you structure of a clear workflow, and it automates the whole creation of documents. So it can speed you up it depends also on whether you have the meetings online or not, what type of meeting, but I would say it's substantial. So maybe 50% less time, 80% less time. I think in the future, this will evolve clear when we have a lot more experience with that.
Yes, I think so too. It's what I can see from my experience now. It's a huge help for the companies who are not structured or do not have legal advisors, and so for them it's a real help, and it also helps me. Then I have to ask less questions, so I get more or less everything prepared pretty well. Of course, it always depends a bit also on the user, but it's guided really well, and it goes faster.
Okay, thank you for your estimation. Are there any more questions from the audience? Please feel free to type them in the chat.
If not, we can conclude this meeting. You see on this slide our contact information. So if you are interested in the general topic of corporate housekeeping, equity management, capital increases, please follow us on LinkedIn and subscribe to our newsletter. We post a lot on those topics. Obviously, if you have specific questions regarding a capital increase endeavor that you plan, please feel free to either contact Nando more on the legal side or myself more on the technical side and the technical support side. And yeah, I'm also happy to show you the software, the benefits of the software in the online demo. So if we do not have any more questions, and I don't see any so far, thank you very much for your attention and have a great day.
Thank you. Bye-bye.
Bye.